Hi everyone, and thanks to CFER for having me. I'm Anastasia Boden. I work at the Pacific Legal Foundation in the Equality and Opportunity Program. I'm a California native. I grew up in California. I went to college in California. I did move away briefly for law school, but for some reason I decided to come back. And so I'm thrilled to know that there is a large contingent of Californians here who actually do care about equality, the real kind, and to be here with you today. So in preparing for this speech, I was thinking about how proud and grateful I am to work for a law firm that represents CFER in several lawsuits. Nowadays, many people feel like they can't talk about equality before the law in the way that you and I see it, in the way that the framers of the 14th Amendment saw it, in the way that civil rights leaders throughout history have seen it, and in the way that the Supreme Court recently affirmed when it handed down its ruling in SFFA versus Harvard. I'm no exception. I know I have personally felt, even when amongst my closest and dearest and longest held friends, that I can't voice my opinions or even experience litigating these issues or even respond in polite conversations because otherwise I might be called, quite ironically, discriminatory. So we at PLF are very lucky to represent an organization like CFER that speaks up, that sues, even when others won't, and that makes sure that our nation's ideals of merit, opportunity, equality, individualism, and colorblindness don't die out simply because people are too afraid to speak. So thank you all for belonging to this wonderful organization, to Wenyuan, who's an incredible advocate for us. And I also want to take just a short moment to recognize Paul Hanash, who's one of our associational plaintiffs in one of our lawsuits, and also Chelsea Boyle, who's here today and who is one of our clients as well. Now, if I think about those who advocate for the race-conscious programs and equity-driven policies that we challenge at Pacific Legal Foundation, I think there is a Venn diagram where we want some of the same things. We want people to thrive. We don't want the circumstances of one's birth to determine their future. We want people to be able to pursue happiness without arbitrary obstacles in their way, let alone the exceptionally arbitrary character of race. So why then is our country so divided when it comes to equality before the law? I think our friends on the other side, as we say in court, misunderstand both the problem and the solution. In terms of the problem, they see everything through a racial lens and expect equal numbers wherever they look. Anytime there isn't equal numbers on the basis of race, they assume it's because of racial discrimination, which then requires rebalancing based on race, also known as racial discrimination, as a solution. But what our friends don't understand, of course, is that we are a country of individuals, and individuals don't act in lockstep with their race. Imbalance is not necessarily a problem. It is the natural result of individuals pursuing their own interests and passions and talents and needs. And in fact, balance is a problem because it necessarily means that someone has tinkered with the numbers. That is, the only way you will get perfectly equal numbers in every school and every workplace and on every board and in every facet of life is if you artificially create balance through a quota system. You only get balance by discriminating. To be clear, unequal numbers can be a problem, but it's only a problem if it results from discrimination. And so the through line is that proponents of DEI see imbalance in itself as the problem, whereas we know that discrimination is the problem. And that's what we work to promote in our equality practice at PLF. We show that equality, as written in the Constitution, doesn't mean equality of outcome. It means equality of freedom, equality of rights, and equality of treatment. And racial discrimination of any kind is not only immoral, but unconstitutional. Now let's talk about the solution. Ironically, those on the other side of the debate think that discrimination is both the problem underlying everything and also the solution to everything. But discrimination can never be a solution because it is inherently arbitrary and pernicious. In fact, there's a much better way to make sure that all people enjoy opportunity and are not held back by any arbitrary circumstances of their birth, and make sure that everyone is equally free to escape those circumstances. And that solution is opportunity. The solution is getting rid of arbitrary, government-created barriers that keep people from pursuing their happiness. People don't need quotas. They need the freedom to succeed. If the government wants to help people, it needs to get out of their way. When the government enacts laws that restricts economic freedom, whether that be through excessive licensing requirements, protectionist regulations, or other forms of economic favoritism, it undermines the very principles of fairness and equality that the 14th Amendment was designed to protect. Civil rights leaders throughout history have recognized this. Martin Luther King Jr. famously said, "Our slogan must not be burn, baby, burn. It must be build, baby, build. Learn, baby, learn, so we can earn, baby, earn." And that's why we, I'll end with it. Maybe I should have. And that's why we at PLF have not just an equality program, but an equality and opportunity program, because we see both of these aspects as fundamental to the 14th Amendment. And I think this really is the key missing piece when we communicate about equality. Often we're advocating against racial preferences, right? And people's immediate thought is, why do you want to take things away from people? How are you going to help those who need help? And this is it. The flip side of the 14th Amendment, which we say means no preferences, is tearing down government barriers that arbitrarily keep people down. No preferences, no barriers. I happen to work mostly on the opportunity side of that equation in our program. My colleague Jack Brown is here today. He's going to speak in a little bit, and he can talk about the actual cases that we are litigating on behalf of CFER. I also see my colleague Andrew Quinio is here, and he's an attorney on some of these CFER cases, and I don't want to upstage them by stealing their talking points. So I thought instead that I would talk about the opportunity side of our work, which is, again, yes, we want no preferences based on race, but we also want no burdens. We want the equal freedom to succeed. So I will start by telling you the story of PLF client. Oh, there we go. This is not, I'll get there in a second, technology. I'll start with the story of PLF client Ursula Newell Davis. Let's see if we can make this work. We're gonna have to show it to you later. Or here, okay, I'll do it. You're just gonna have to bear with me. Okay, there we go, technology. Ursula Newell Davis, this was my client, one of my lawsuits, is a social worker. She's an entrepreneur, and she is a mother of a special needs child in New Orleans, Louisiana. In her capacity as a social worker, she saw that when parents don't have access to care, they are forced into one of two options: either not doing the thing that they need to do, that might be going to work, getting groceries, running basic errands, taking time to themselves, or they're forced to leave their children home alone. And for some parents, they have to leave their kids alone because they need to get to work. And when it comes to special needs children, this can mean that these unsupervised children don't complete basic tasks like their homework or feeding themselves or bathing themselves or changing their clothes. And in some cases, this has even resulted in these children being bullied at school the next day because they're not keeping up with basic hygiene. Alternatively, these children might be eager for attention or approval, and so they might wind up involved in crime. And Ursula saw this as a social worker, and her clients were begging her to provide care, and so she set out to provide this care for special needs kids through what's called respite care in Louisiana. Respite care is care designed to give people relief from the rigors of rearing children, and particularly special needs children. But Ursula didn't just do it for the children. As a mother of a special needs parent herself, of a special needs kid herself, she understands the rigors of raising a special needs child. And anybody who's had any involvement with special needs children knows this, that there's a good deal of love. I have this in my family. There's an amazing amount of love. People also need time for themselves, for their mental health. She was fortunate enough to have a huge support system, and she knows what it's like, though, to struggle when you don't. And so she wanted to start this business not only for the children, but for the parents. She also knew that parents don't just necessarily want the caregiver down the street. It's not easy to leave your special needs child with a stranger. They wanted somebody that they knew and could trust, like Ursula, who had been their social worker for some time. But when Ursula submitted the first step in the application process, Louisiana denied her in a 2-page form letter on the theory that her business wasn't needed. Now, the denial had nothing to do with her qualifications. How could it? The state never said she's unqualified, but she has a master's in child development. She's been a social worker for many decades. She's the mother of a special needs child. She's arguably one of the most qualified people to provide this service. Yet still, this panel of bureaucrats looked at her application and deemed her unnecessary. Now, what they meant by this was when they ran the numbers, in their minds, there were enough respite providers in New Orleans. But need is not a pure numbers game. Need is a matter of personal preference. These parents may have had respite care in the area, but they didn't want that business. They wanted Ursula, and they knew and they trusted her to have the skills and the relationship necessary to take care of their child. As Ursula said, there might be 10,000 businesses in Louisiana, but none of them are Ursula Newell Davis. So even if we did play the government's numbers games, number-wise, there was a need for more respite providers. Ursula had seen firsthand mothers desperate for good care. One mother testified during the lawsuit that without access to this care, she had eventually lost her job, then her home, and she had contemplated when she was at rock bottom the, as she put it, unfathomable choice of giving up her child for adoption. Fortunately, she found Ursula, who was a social worker, and helped in as she could and helped her find resources, and she was able to keep her child. But not everybody has a resource like Ursula. What's more, during litigation, the state's own expert testified that 75% of the respite care businesses in Louisiana were not returning calls. And one of the department's own employees testified that there's always, quote, always a need for more respite care in the state. So why does Louisiana have this law? We asked them in litigation, and their only answer was that rather than licensing anybody new, they'd rather save their money for regulating the existing licensees. And they said that saving money and using it on the existing licensees necessarily benefits the public. No evidence, nothing, just that bare statement. Of course, all the evidence shows just the opposite. The research shows that when you restrict qualified people like Ursula Newell Davis from providing care, the quality goes down, access goes down, and cost goes up. Nevertheless, we lost Ursula's case. We lost because the 14th Amendment has been turned on its head, with people saying that equality means discrimination and opportunity means hands out and preferences, not economic freedom. Economic freedom, some say, is only for the rich, but in fact, it is essential for everyone. We don't want equality of outcome. Inequality signals merit. We want to make sure that those on the bottom do okay, and the way to do that is by giving them opportunity too. Even in a world where you have the biggest wealth gap, the poorest in that society might be better off as long as everyone is brought up. It's not about the gap, it's about how we're doing for a poor segment of society. When I think about Ursula, I think that this is exactly the kind of person that the 14th Amendment was written for. A woman being kept out of her job by powerful interests who don't want competition. That is not equal rights. There can be no equality for Ursula or the children or the parents she serves without economic opportunity. So I wanted to give you another example here of one of our opportunity cases. This is Philip Truesdell. He's in the non-emergency ambulance business. So what does that mean? Well, not all of the ambulances that you see are ones that you see on TV. When people are simply confined to a stretcher, or maybe they need an IV, or they're undergoing dialysis, they can't just jump in an Uber. They need to get where they're going, even if it's not an emergency basis, but let's say to a medical appointment, by ambulance. They need an ambulance to get around. So Philip got the idea to start a non-emergency medical transport business in 2017 when his local power plant was shutting down. His family was going to lose, they were all going to lose their jobs. In fact, some of his family was going to have to move away out of the city to get a job, and he didn't want his kids and grandbabies, as he calls them, to grow up so far away. So he saw a for sale sign on an ambulance on the side of the road, and he thought, hey, that's a great way to keep my family here. He started Legacy with one ambulance. He named it Legacy to say that it was about the legacy that it was leaving for his kids and grandkids. He started with one ambulance, and he quickly grew to 7 trucks, making more than 1,500 trips a year. So the Truesdells decided they wanted to expand into neighboring Kentucky. Kentucky is just a throw of a rock away. It's about a mile away over the river. But they were shut down there by the existing businesses, which enjoy a veto power over any new competition. This competitor's veto law has led to cartel-like behavior throughout Kentucky and throughout the entire healthcare sector. Hospitals, birthing centers, emergency ambulance businesses must also surmount a competitor's veto in order to start up. As you can imagine, this wreaks havoc on the communities there, and Philip lives in a very rural and poor community, and they are suffering with much worse emergency ambulance times than the national average. And when I asked Philip about why he did this lawsuit and who he thinks should be able to start a non-emergency ambulance business, he said, anyone who has breath in them. This is what the 14th Amendment was written for, to make sure that all people have the equal ability to pursue their dream. And in Philip's case, that means providing an invaluable service to his community and allowing him and his family to stay together. When we refuse to look at opportunity as a solution, that's when we leave political minorities of all kinds behind, because the people who lose out in the political system are those people who cannot protect themselves at the legislature, the people who don't have the political clout to stop anti-competitive or burdensome laws from being passed. So the people who suffer are political minorities of all kinds, whether that be racial, ethnic, religious, and of course, the smallest minority is the individual, because they can't fight back against oppressive laws. The framers of our Constitution knew this. According to James Madison, it is not a just government, nor is property secure under it, where arbitrary restrictions, exemptions, and monopolies deny to part of its citizens that free use of their faculties and free choice of their occupations, which not only constitute their property in the general sense of the word, but are the means of acquiring property. As one congressman said during the debates over the 14th Amendment, so that was over a century later, it is idle to say that a citizen shall have the right to life, yet to deny him the right to labor whereby alone he can live. It is a mockery to say that a citizen may have a right to live, and yet deny him the right to make a contract to secure the privilege and rewards of labor. So, in other words, I'm not just making all of this up. The framers knew economic opportunity was a vital constitutional right, and in fact, they saw it as necessary to the true realization of equality before the law in this country. So I wanted just to tell one last very short story here, because I think it's particularly relevant to you all and to CFER. So this is Artie Vogt. When I met Artie, he had recently been denied permission to operate his moving business in West Virginia. He had started his company in his 20s. He had started at the company in his 20s as a driver, straight out of college. And he eventually worked his way up, saving his money over the years. And after some time, he was able to buy the company with his wife, Stephanie. But he didn't know that when he bought the company, the license did not transfer over with the purchase. So eventually, one of his competitors figures this out, and they rat him out, and they say he's operating without a license. This is not just any license. This is, again, one of those competitors' veto states, where in order to get a license, you have to prove that your business is needed and overcome your competitor's veto. So Artie doesn't know this, and he thinks, well, this should be easy. I've been operating for a decade. This company has been operating for over 100 years. Clearly, we are needed. But you probably know the rest. He applies, some company protests his application, and they say he's not needed. And a year and $10,000 in legal fees later, he was denied. Shortly after that, his wife Stephanie died of cancer. Shortly after that, I contacted him and asked him if he wanted to bring a lawsuit. And after we sued, it was a very hard-fought fight. Right at the very end of litigation, right when we were going to get a decision from the judge, West Virginia repealed the Certificate of Need law. That's, you know, as a lawyer, you always want the legal victory, but you have to be happy when you make people freer than they were the day before. So we were very happy for Artie. There's a very moving video of Artie after he found out that the law passed, where with tears in his eyes, he says he's really proud. Makes me emotional, sorry. He's really proud to have gotten the law passed because he's going to name it Stephanie's Law after his wife. So I bring up Artie because a couple of years ago I was trying to get in touch with him and he wasn't answering my emails, which is very unusual. He's a big fan of PLF, as you can imagine. So I was starting to Google him. I was scrolling through the results and I stumbled upon his obituary. And I opened it up and it's just a short little thing. You know, he was a simple man from rural Virginia. It says he was born, these were his parents, this was with his wife, and this is when he passed away. Except his obituary had one more thing, and it talks about the lawsuit and how that was the proudest thing he had done in his life. So it's no simple thing to be a plaintiff in a civil rights lawsuit, but brave people like Artie, organizations like CFER, they do it because they know it's important and they're fighting for something meaningful and vital, the principles of equality and opportunity that the 14th Amendment was meant to guarantee. PLF and I were all so honored to represent people like Artie, Philip, and Ursula. When courts strike down laws that unfairly restrict economic freedom, these rulings help to ensure that Americans have the opportunity to pursue their dreams and to provide for their families, regardless of background or economic status. Economic opportunity is a key component of equality. And we are also very proud to represent CFER. When courts strike down laws that treat people differently on the basis of race, in the name of equality, they restore the true meaning of the 14th Amendment. They ensure that each of us are treated as individuals and that we are more than simply members of the racial groups that we are born into. We have more importance than our skin color. Discrimination is the disease, equality and opportunity are the cure. This is a vital part of our message if we're going to change hearts and minds and legal precedent. And I think it's important that we emphasize these two pieces of the 14th Amendment together. Thanks so much for having me.